Muy buenas tardes. En nombre de la Facultad de Ciencias Jurídicas, Humanidades y Relaciones Internacionales de la Universidad Americana y de Internet Society, les damos la más cordial bienvenida a la conferencia de decisiones judiciales que han modelado en Internet. Muchas gracias por su participación. Este es un evento que busca reflexionar sobre cómo el derecho y los avances tecnológicos han moldeado el Internet y qué papel juegan los tribunales para el futuro de Internet. Para dar inicio a esta actividad, vamos a pedir a la profesora Alicia Cortés, decana de la Facultad de Ciencias Jurídicas, Humanidades y Relaciones Internacionales de la UAM, que nos regale sus palabras de bienvenida.
Gracias, profesor Carlos Leal. Buenas tardes, estudiantes, profesores, profesor invitado, doctor Holt, doctora Tania Valenzuela, directora académica de esta universidad. Es un verdadero honor darles la más cordial bienvenida a esta conferencia, Decisiones Judiciales que han moldeado el Internet. Este evento, sin duda alguna, a través de la articulación como miembros de Internet Society, reúne voces expertas y comprometidas con el análisis crítico en el papel que juega y desempeñan las decisiones judiciales en la configuración en el entorno digital que conocemos en estos tiempos. Vivimos sin duda alguna en tiempos en los que el derecho se ve desafiado constantemente por fenómenos tecnológicos o avances tecnológicos disruptivos, ¿verdad? Como diferentes herramientas de inteligencia artificial que estamos conscientes que están en una evolución constante que nos llevan además una ventaja de sobremanera. Cada fallo judicial en esta materia no solo resuelve un caso en particular, sino que construye, interpreta y en muchos casos hasta redefine los límites de nuestras libertades y derechos en el espacio digital. En este sentido, esta conferencia representa una oportunidad invaluable para reflexionar sobre cómo hemos actuado desde el pasado en nuestro actuar y ejercicio, desde el ejercicio profesional, cómo es el actuar del presente, cómo hemos evolucionado y cómo vislumbramos el futuro en el derecho en esta era del Internet, aprovechando todas estas herramientas digitales que el día de hoy tenemos. Quiero expresar un profundo agradecimiento muy especial al doctor Joseph Lorenzo Hall, miembro del equipo técnico de Internet Society, por honrarnos con su participación. Su presencia definitivamente en esta jornada aporta una perspectiva global y altamente especializada. Y estoy segura que este conversatorio va a despertar en ustedes ese pensamiento crítico y esas reflexiones de cómo estamos en el derecho. Nuestra facultad se enorgullece de facilitar este espacio de intercambio interdisciplinario donde el rigor jurídico y la innovación tecnológica se encuentran para generar este conocimiento útil. Muchas gracias a todos. Bienvenido, doctor Paul.
Thank you so much. I wish I could give this talk in español.
Muchas gracias, decana. Y nos sentimos muy honrados de dar la bienvenida a nuestro orador invitado, el doctor Joseph Hall, quien es un reconocido experto en Derecho, Tecnología y Políticas en Internet. Su trabajo se ha destacado por la lucha en protección de los derechos de las personas en línea y en promover una Internet abierta y segura. La presentación que va a hacer el doctor va a ser en inglés y va a ser sobre las decisiones judiciales, los malentendidos tecnológicos y los conflictos globales que han afectado al Internet. Después de la presentación del doctor, ustedes pueden hacer sus preguntas. Hemos compartido previamente a la sesión un número por WhatsApp para que me hagan llegar las preguntas. Vamos a hacer un regalo al doctor vía chat. Y nosotros estamos muy agradecidos con el doctor por la ponencia. Voy a cambiar al inglés. For us, it's a great honor to welcome to our special guest, Dr. Hall. He is a leading expert in internet law, technology, and policy. His work focuses on defending people's rights online and supporting an open and secure internet. Today, he will talk about how court decision misunderstanding about technology and global conflicts affect the internet. After he talks, you will have the chance to ask questions. Dear Dr. Hall, please go ahead.
Thank you, and sorry for interrupting you earlier. I understand written and spoken Spanish almost perfectly, thanks to my abuelita in Nuevo Mexico, but my capacity to speak is really limited. And so I hope to one day be able to give this kind of talk in Espanol to my amigos Hispanohablantes. But it's not today, I'm sorry. But you can ask questions in Spanish and I can understand them and repeat in English. Anyway, that's enough about my ridiculous 1.5 languages that I have within me. Thank you so much. It's such an honor to be able to talk to you all. I think of folks like you as internet law nerds in a sense, people who understand that there's a real need to bring expertise and technology to the field of law so that we make the right decisions. So that's what I'll talk about, and then we'll leave plenty of time for questions. I tend to speak very fast at times, so you'll see me trying to stop and slow down. And hopefully, if I speak too quickly, someone can give me a sign. Carlos, maybe you can. Anyway, so moving right along. One of the big questions that we'll talk about today is what happens when the law misunderstands technology. Imagine that you go to a court website, you're trying to watch the arguments online like we do so often these days, maybe right at this court website, which is the U.S. Ninth Circuit. And then suddenly you're trying to access the documents and they're just gone, completely gone, replaced by an empty box. This visual that I'm showing you, and I'll show you another version of this in a moment, tries to capture what could happen if courts misunderstand a fundamental everyday technology of the web, something called embedding. And I'll talk more about that. This issue was at the heart of a court case in the US called Hunley versus Instagram. It raises a really critical challenge. What happens when the legal system does not fully grasp the technology it's making decisions about? And increasingly, there's a lot of technology out there. The consequences can be really significant and potentially break parts of the internet and the web that we rely on every day. A little bit about me, bridging that gap that I talk about, ensuring technology is properly understood in both legal and policy context. It's really core to my work, and it's fundamental to the mission of the Internet Society where I work. And the Nicaraguan chapter is one of 120 chapters around the world that are all enthusiasts about this kind of stuff. I'm a distinguished technologist. It just means I'm a really old, massive nerd. I'm at the Internet Society, and my background is right at that intersection. After leaving astrophysics in the early 2000s, I studied information systems, and specifically my PhD looked at transparency and specifically electronic voting systems. How do we make sure that these computers that increasingly count our votes online are honest? And my thesis walks through, can we use contracts? What about trade secrecy? What about open source code? What about statistical auditing? And if you love that stuff, you'll love my thesis, but I never recommend anyone read it. But for years, both here at the Internet Society, where I work today, and previously at the Center for Democracy and Technology, one of my biggest things has been translating between the worlds of code and the worlds of law. Coders think the law is magic. Lawyers think code is magic, and it's not magic. All of this stuff is things that we can all understand and manipulate with our hands and brains, right? Let me talk a little bit about the Internet Society for those of you who are not familiar with it. We're a global nonprofit charity. We're dedicated to ensuring that the internet remains open, globally connected, secure, and trustworthy. Truly, we try and build an internet for everyone. Our strategy that we've been working on for a while now, but aiming towards 2030, guides our work, and it's really simple. First, people need basic connectivity. We have to get those that are offline, online, and for them to be able to enjoy the opportunities that the internet can provide. Second, that connection that they have, it needs to be affordable, or you don't have it. It has to be reliable, or you can't keep it. And it'll fall down all the time and not work. Third, people really need to feel safe online. They have to have the confidence to use the tools that we have on the internet to make their lives better and to do fun things too, right? But fourth, the internet itself has to remain healthy. We have to work to make sure that the internet doesn't get sick, so to speak. And what I mean by that is it needs to be technically sound, it needs to be open with low barriers, and we all need to be able to trust it. Fifth, we need data to understand the internet's health and improve the impact we make. And finally, sixth, all this requires collaboration, mobilizing folks, working with people on the ground in our community, chapters like ISOC Nicaragua, partners and institutions. This is all this is part of what we do. And today's discussion touches right on several of these areas, including the healthy and trustworthy internet, making sure people can stay safe online, and the importance of collaboration. Okay. So let's dive a little bit deeper into that first challenge, the risks when legal systems grapple with unfamiliar technology. I'll use the Hunley case as our main example. What is embedding? If you've written any web code, you may be familiar with it, but essentially it's like putting a window on your web page that looks through to content hosted somewhere else. When you, for example, embed a YouTube video like this on a blog or a court website, you're not actually copying the video, you're linking to it on YouTube servers. And it plays on your page, but from somewhere else on the internet. It's one of the harder things to understand, but it makes the internet really dynamic. And you can put in little widgets, you can put in accessibility tools for people who have low vision or other kinds of cognitive disabilities that help them understand what a court case is doing. You can do things like change fonts. You can do things, this is kind of controversial, like make derivative works and mark up someone else's web page and share the markup with other people. There's a lot of things you can do with embedding. In this case, particular in Hunley, the legal question boiled down to whether embedding a photo constituted copyright infringement by the website doing the embedding. So I have a website, josephhall.org. If I embed a photo from Instagram, that Instagram is providing all the code, but the images are from their users, from Instagram's users. The people who put those images up own the copyright. And so the theory was photographers were upset that Instagram was allowing people to embed their photos all around the web, even though the license says this is something you can do. And even though the tools say you could check this box to not share your photos if you don't want to. But because of that, they sued for copyright infringement. The lower courts were all over the place, sort of. The lower court was all over the place in this case. But this is where folks like the Internet Society and you all can step in. There are lots of different amicus programs. We have an amicus program, and we file, amicus is Latin for friend of the court, amicus curiae, friend of the court, and we file friend of court case in friend of the court briefs in cases like this around the world. There's about 33 countries that allow third parties to intervene in their legal processes. And there's things like the European Court of Human Rights and things like that, where you have very similar kinds of processes. There are also countries like Australia is a good example where the government chooses and finances friends of the court. So there's never third parties. Anyway, that's a little thing. But through this program, by intervening in cases around the world, our goal isn't to support a party or the other, but to come in and provide crucial technical content that the court might not have. You know, when people fight in legal cases, they often are keeping their interests closely guarded, and they may not have time to save the internet in the process, right? They may care about other things. In our Hunley brief, which I can provide you if you want to read it, we explained how embedding works technically. And critically, we pointed out that ruling against embedding could really break vast swaths of the internet and the web, including, ironically, the court's own website, which relied, as you can see here, on embedding for videos and for videos of the arguments and for displaying documents on their web page. So we were able to show them in the brief itself, hey, if you rule this way, here's what your website's going to look like. You're going to make your website look bad. And the judges are like, oh, gosh, I don't think that's a very good idea. But we aim to prevent a ruling based on misunderstandings that could have had a widespread negative consequences for online communication and information sharing. Embedding is fundamental online. So moving right along, it's not just confined to the U.S., this need for technical clarity in the judicial system. It's all around the world. The Internet Society and our Amicus program operates globally, and for instance, in Mexico, we participated in the Richter v. Google case. Richter is a very, very wealthy lawyer who is upset that Google allowed a blog post that basically smeared him. And he says that was defamatory. It was really just someone mad at him. And when, rich people get mad at other people get mad at them, they sue them for defamation. Billionaires are bad. But in this Richter versus Google case, the case touched on a really crucial issue, that of intermediary liability protections, right? Those are the rules that generally shield platforms from legal responsibility for content posted by their users, right? Why would a phone company offer a phone service if they have to potentially be liable for anything that someone says over the phone? It's a very similar kind of situation. These, what we call intermediary liability protections, are vital for online services. They're vital for social media. They're vital for access to information worldwide. Our brief in this case provided a perspective on how those protections support the internet ecosystem in Mexico and beyond, and that it's crucial that courts everywhere understand these dynamics. But that's not just that's not the only thing here. We also see really weird developments in our own backyard. So, for example, there's new legislation that might be well-intentioned, but is technically problematic. And one of those examples is recent efforts in many U.S. states and in whole countries like Australia. And in Texas, there was a case that went all the way to the Supreme Court in the U.S., and we're waiting for the Supreme Court to make a decision that that mandated age verification for accessing certain websites, websites with significant amounts of adult content, which the way they measure it, Netflix ends up being something that has significant amounts of adult content, even though it's not an adult-only website. But in that case, the goal was, or in the law that the case is about, the goal is child safety. And we're 100% for child safety. No one's against I'm sure there's somebody against child safety, but it's really important, and especially now, given the wild, wild west, so to speak, that the internet is. And the technical methods, unfortunately, for reliable age verification online are unfortunately often invasive, insecure, or they just don't work well and easily circumvented. Those technical tools can compromise user privacy and security. So in a case like this, ISOC comes in and we provide input highlighting the technical realities and potential unintended consequences. We try to urge lawmakers in the courts to consider solutions that are effective and technically sound, rather than just thinking, well, let's do something. Just doing something can often get a lot of people hurt. And that directly links to the things that we care about in terms of online trust and safety. You'll see people say, well, geez, you have to show a photo ID in the real world to gain access to certain spaces, to gain access to certain kinds of adult things, be it pornography, be it tobacco, be it alcohol, all those kinds of things, be it ammunition. And yeah, that makes sense. But online, increasingly, we're very quickly going to a place where everyone is going to have to verify their age for access to almost anything. Depending on the law, right? And unfortunately, what that means is you're going to end up sharing sometimes government IDs with domains you have no idea what they're doing with it. It's unfortunate. It's very ripe for identity theft and things like that. But in all of these instances, the core idea is the same. We want to ensure the courts and then policymakers have the necessary technical understanding to make informed decisions that don't inadvertently harm the structure of the internet or the rights of users. That's a really important thing. The internet allows people to exercise rights they didn't have before. They couldn't exercise in those ways before. The second topic is thinking about the fundamental legal pillars that shape the modern internet. And the important piece here is that the relationship between the law and the internet is not just about courts trying to catch up or fix misunderstandings. There have been some foundational legal decisions that have actively shaped the open, innovative, and dynamic internet. And I wanted to raise just a couple of examples. And if you've ever taken a cyber law class, you probably have heard of these, and so you can look at your phone for a moment or something, but I thought it's important to raise. But perhaps one of the most significant legal pillars, particularly in the United States, but with very global resonance given the dominance of United States tech platforms, is the concept of intermediary liability protection I was talking about a little while ago. But in the case of Mexico, which is complicated where that source of authority comes from, ask me a question if you want in the Q&A. But the landmark case here is called ACLU versus Reno, and it's worth a read. It upheld Section 230 of the U.S. Communications Decency Act. And what does that do? Broadly speaking, it says that online platforms, social media sites, forums, service providers are generally not legally responsible for the content posted by their users. You know, you think about YouTube that gets, hundreds of thousands of hours of video every day. There's just no way to examine something as complicated as high definition video for arbitrary things like terrorism content. Like, what does that even mean, right? And that's really the key of the issue. Are we offloading social problems to technical tools that may not be able to do the things we think they can do with the level of precision we think they can do? But think about it. Without that kind of intermediary liability protection, could platforms risk hosting vast amounts of user commentary with reviews, videos, discussions? There's just no way they could do it. They would have to curate them. It would increasingly look like cable television, where there are, cut channels that they know what people are going to offer, and there's consequences if you don't offer the things they think you're going to offer. But Section 230 is often credited with 26 words. It's often credited with allowing the user-generated web and internet to flourish. It has created space for innovation and fostered unprecedented levels of online expression around the world. It's certainly debated today. And in fact, we have produced a very lengthy report that sort of talks about all the places in the internet that blunt hammers, so very imprecise tools, could cause problems with other pieces of the internet. So say you're trying to regulate or legislate something about the applications of the internet, and you don't do it with thinking that there may be other things underneath the applications that you can affect, and that can be pretty bad. Things like the DNS, things like how the internet is routed, all sorts of things. And the Section 230 is debated today. In fact, there are bills in the United States that would repeal it entirely or do certain things to it to modify it, and happy to discuss those. But there are ongoing discussions about things like this: content moderation, platform responsibility, and potential reforms. And you can see that echoing around the world, where there's a variety of different approaches to this. It's never been a better time to be working in internet law, let me tell you. But the foundational role of intermediary liability in shaping this internet that we know is undeniable. Protecting those principles are really important to us at the Internet Society, and thinking about, if they do need updating, what are the ways that we can precisely target updates to the law or to the jurisprudence, so to speak, to make sure that we do the right thing. The second critical legal principle I wanted to bring up is the recognition that software code itself can be a form of speech. My PhD advisor at Berkeley was Pam Samuelson. She's the goddess of copyright. She beat the law into me. No, I'm just kidding. She's a wonderful, wonderful person. But she used to say that software is the only thing that's protected by all four forms of intellectual property, right? Trade secrecy, copyright, trademark, and patent. Right? I guess there's a couple other ones like rights of publicity, but whatever. I don't think, maybe AI could result in software that actually has a publicity right. I don't think so. I think those only go to natural persons. Anyway, I just geeked out on my own talk. I'm sorry. So the key case in the code speech area is called Bernstein versus USA. It's also very worth the read, the Ninth Circuit decision that I've linked to here. Daniel J. Bernstein, DJB, to some who know him, is a mathematician and a cryptographer. He wanted to publish his encryption software. This is like 1994 or something. He had an encryption software called Snuffle, S-N-U-F-F-L-E, Don't know what the heck that means. At the time, the US export regulations treated encryption software like munitions, like weapons of war. They still treat software and encryption software like weapons of war when it's not a weapon, not even close. It was in the 90s maybe, but it's not anymore. The court here ultimately agreed that publishing this source code was a form of speech protected by the First Amendment of the US Constitution. Why is that important at all? Well, it established crucial protections for the freedom to develop, the freedom to share, the freedom to research, and the freedom to use cryptographic tools. And I can't stress this enough, encryption is fundamental to online security and privacy. It is the glue or the mortar that holds the bricks of our digital buildings together. It protects everything from your online banking to private messages, to your medical records, to anything, unless it's broken, in which case there are a couple cases that things are not protected. But legal decisions like this, like Bernstein, helped ensure that the tools that we needed to secure the online environment could be freely and developed and distributed. So there's 30 years, well, almost 30 years of this environment allowing us to build and create our own tools in our houses with our fingers writing code that ultimately went on to protect the entire internet. We've never seen that in the history of human evolution and scientific development. But this part directly speaks to the things we care about at the Internet Society when it comes to online trust and safety, when it comes to the technical health of an open and trustworthy internet. And defending that strong encryption is a major focus for the Internet Society today. If you're not a member, please consider joining the Global Encryption Coalition at globalencryption.org. If you believe in strong encryption, it's a really good group to be a part of. Okay, so wrapping it all up, we've seen two sides of the coin, so to speak. Law acting as a foundational pillar that shapes the internet through decisions like the ACLU versus Reno and Bernstein. And then the first part, the crucial need for the legal system to understand the technology it governs, is highlighted by the cases Hunley and Richter. And one of the people I work with at the Internet Society, John Morris, is famous for, in the ACL v. Reno case, bringing computers into the courtroom. This is way before there were computers in anyone's courtroom, and actually showing them how email works. And that was fundamentally a big part of why that decision went that way. It's not in the decision because the judges don't say, thank you for this demonstration that really let us understand the power of internet communications. But there's all sorts of fun little stories like that. So what are the takeaways here? There's a really vast, important, and constantly evolving surface area, so to speak, where law and technology meet. And hopefully they don't collide. Hopefully they resonate with each other. Navigating this space requires expertise, people who can understand both the technical nuances and the legal principles, and people who aren't afraid of either of them. You really need to grapple with the details of both the law and of technology to be able to make any significant progress in either area. And for any of the law students that might be in the audience, and for everyone involved with ISOC Nicaragua, your skills are incredibly valuable, especially in Espanol. Whether you end up drafting policy, litigating cases, advising companies, or working in advocacy like I do, having that ability to bridge the gap between law and technology is increasingly critical. And if you want to be marketable and have a good career, let me tell you, being able to switch quickly is a really good skill to have. You have the opportunity to directly contribute to defending and strengthening an internet that works for everyone. There in Nicaragua, globally, across Central America, across both of our continents, despite the fact that my president is trying to mess everything up. But through this collaboration between people on the ground, those of us that work on the global level, trying to make sure people have resources and information to do what they want to do and what they need to do. This is often the key to what we do, and people are the central part of all of it. Anyway, the internet continues to evolve, and the legal and policy challenges will only get more complicated and more active all around the world. It's going to take an army, and it's a really exciting time to be engaged in this work. Happy to take some preguntas. Feel free to ask them in Spanish. I may have to ask you to define a word or something, but hopefully I didn't speak too quickly.
Okay, thank you very much, Dr. Hart, for your clear and inspiring talk. Bueno, él dijo de que le podemos hacer preguntas en español, si le hablamos despacio, él nos entiende, y pues, que hay una pregunta. ¿Verdad?
Muy agradecida, doctor Joseph, por su magnífica ponencia. Ciertamente incluye este tema un estudio interdisciplinario, ¿verdad? Desde su área de expertise y desde el rol que ejerce el abogado en el ejercicio legal. Yo sí tengo una pregunta mientras nuestros estudiantes se van animando para hacer alguna de ellas, y es que ¿qué problemas evidencia usted o cómo puede afectar el embedding de información legal en sistemas automatizados, afectar la interpretación y la aplicación de la ley? Dado que si esta va a ser una de las principales herramientas que ayuden o coadyuven a la agilización en el ejercicio legal, ¿qué certezas o garantías encontramos tanto en la encriptación o el embedding de la información traducida en el ergo legal?
So I got 90% of that. But you're asking about how do we affect the tools that are increasingly being used to work with the law? Is that correct?
Yes, to ensure the correct application.
Yeah, that's really interesting, and it's we live in such a strange time because never have we had so many tools, but never have the tools been of sort of dubious quality. Like I can't tell you, every week you see some lawyer getting taken to task by a judge for using ChatGPT, which makes up cases apparently like left and right, and no lawyer seems to learn from the other lawyers that have done this. But you're right, like at Berkeley when I was a grad student. One of my grad students with me was a really neat guy named Mike Listener, and he created courtlistener.com. And if you go to courtlistener.com, it's essentially a one-stop shop for every single judicial opinion in the United States whatsoever. And they have donations of legal opinions because they charge in the US for legal opinions, like by the page. It's really stupid. And so there are tools that allow us to democratize the work of lawyering, of the work of practicing law, and things like that really help to make sure that people like me who don't have a lot of money to access LexisNexis or Westlaw, the dominant tools we use in the United States, that we can have most of what we need and then ask counsel or experts to help us with the other pieces. I do think there's going to be an increasing need for legally specific artificial intelligence, things that can do some of the thinking that we do to sort of offload some of the routine things that we do that we shouldn't have to think about so much. We should spend our time on the hard problems, but the trouble I have is, when do you know the tools aren't going to get you in trouble, right? And right now, it feels like it's more work to use the tools than to not use the tools, because you do all this work while you use the tools, and then you got to check all of the work from the tools. So it just feels, I don't have a very good answer, I must admit. I do think that there are a lot of companies that, for those of you that are coming up as young attorneys or people who want to change in your career, they're increasingly, it's not like these big tech companies just have a legal team. They have lawyers embedded in privacy teams. They have lawyers embedded in coding teams. They have attorneys embedded everywhere. And it's because, for whatever reason, you can't easily translate that stuff, or the way that people learn to think as a lawyer. And so there's increasingly getting jobs at people making the tools. One, you'll make good money if you care about that. But two, you'll be able to affect the tools that people are using right now. And the problem I have is that it's hard to know exactly where those things are happening. But that was a very long-winded and probably unsatisfying answer.
Thank you. ¿Alguna otra pregunta? Bien.
Yeah, hi, Mr. Hall, Dr. Hall. There's a quick question. According to the Register versus Google case, understanding that Google as a tech giant, I get the whole picture that Google as a tech giant is, and they have an intermediary between Google and the world. And then there's a blog, and then people are able to post any things that they can post. But the question is that as a tech giant or as one of the main tech giants in the world, Google must have different systems that protect the information that they feed out and that they feed out to the people. And I don't understand how they don't have that kind of system where they claim that they're going to appeal in the Supreme Court. It doesn't really make much sense because having and as you said, they have different lawyers in different departments. So they should have such systems that protect the information that they're sending out because as you know, right now, the children have access to almost all the tech, and then that then becomes a problem. Whether they can just say that, oh, they're not liable for the damages because they're just like an intermediary, which really doesn't make any sense because they should have a system to protect that. Right? That's one of the problems I have with that because then it makes it look like there are no laws. This doesn't mean that there needs to be new legislation that protects or that holds down these tech giants because normally we know that even though we saw the case between TikTok and the nation in America, and we can see that even though there are so many cases like that, these tech giants are able to protect themselves, they are able to lobby, and that becomes a problem. So then how do these tech giants, or how can we create legislation that is able to cut down on such a problem? That's just the first question I have. Thank you.
Yeah, thank you so much for the question. Thank you so much for the question. You're right. Google and other big tech giants are very good at certain things. And so, for example, if you ever have used the Chrome browser or the Firefox browser, if you ever try to visit a malware link, they have a whole set of systems that know how to detect malware links and know how to keep you from visiting them unless you know some tricks to get them if you're a researcher or something. But in those cases, it's unambiguous that that's bad. You know, both the users don't want it and Google doesn't want it. And you can create a very simple technical system that can very easily distinguish between bad and good. Whereas with a blog post that's defamatory with over 400 million blogs on Blogspot, there's just no way to make a black and white decision about everything you're posting. And if you have to do that, they're just not going to offer the service. And that, you know, maybe that's okay. And we don't want an internet that has lots of services. But I think the thing we think about are what are the minimal changes you can make to align incentives better. And I'll point you to this paper we wrote that talks about in this kind of a case with defamation, we have to have very, very clear laws about what kind of content is considered defamatory. And the second that a court rules this is harming an individual, this piece of speech on the internet is harming an individual, Google should have to take that down, right? And right now, none of that exists. There's just no clarity. The laws are very strange. And Google, obviously, they're not going to, I don't think, I mean, I can't speak for them. I don't think they're going to spend money trying to pass laws that put obligations on them. In fact, they probably spend money against those kinds of laws. In certain cases with child online safety, I think there's much easier answers, like places for children to go be kids and for them to, you know, have safe spaces. The trick is that we often treat kids as a monolith, right? Like I have a colleague who has very smart children and they love reading Wikipedia, like 6 years old, like reads Wikipedia, like that's pretty wild. And watching basketball games from the 1970s. And apparently basketball games from the 1970s are not considered kid appropriate. I don't think it's because there's anything bad. I think it's they just don't think kids are going to look at that stuff. So I think that when it comes down to legislation, we have a very long report that talks about how precisely you can engineer these things. And when it comes to defamation, that's one of the harder ones, given that the laws change. And not only that, but the common law is so different in many places that it's really hard to say something generic that's going to work everywhere. I do think that if you come up with a clear definition of harm and the speech act that caused the harm, you can get courts to rule, and folks like Google will obey the law. I mean, in this case, Richter sued based on non-response from Google after Google had determined that it was just the blog that was up there was kind of a parody rather than defamation. But the guy considered it to be defamatory. He says, "I'm being harmed every day this is up there," when it was mostly not that way. So there was mostly a dispute about what you believe about what someone says rather than a black and white kind of a thing. So I'm, again, not giving you a very good answer. Yeah.
Thank you very much, Dr. Hall. ¿Alguien tiene alguna otra pregunta?
Me va a disculpar que se la tengan que hacer en español, la verdad, porque creo que sea la adecuada para la instancia, pero yo quería hacerle una pregunta un poco más en la parte de los bienes digitales. En Estados Unidos entiendo que hay una lucha por definir qué es un bien digital, e incluso una ley llamada AB 2624 que obligaba a que las empresas, a la hora de hacer una compra de un medio digital, no lo nombraran como compra, sino como simplemente la cesión de una licencia de uso. Y mi pregunta es, ¿usted está de parte de definir claramente qué son bienes digitales o simples licencias de uso? Porque en mi criterio, y eso se lo agrego yo, está afectando al consumidor, por ejemplo, porque las empresas tienen la discreción de en cualquier momento arrebatarte el producto por el que pagaste y que en teoría durante muchos años formó parte de tu patrimonio y están dejando en total vulnerabilidad al consumidor. En este sentido, yo le quiero consultar, y mi pregunta, ¿usted qué cree que debería hacerse con una evolución de la legislación tanto de Estados Unidos como en diferentes países para proteger al consumidor? Yo considero que la vía más correcta es dejarlos definidos como bienes digitales, porque si los definís como bienes digitales permite sugerir que forman parte de tu patrimonio, y formando parte de tu patrimonio, vos tenés el derecho no solamente de usarlos, sino de heredarlos incluso, que en el ámbito de los medios digitales es algo importante. Habla ahora que estamos hablando de un mundo globalizado, que hay mayor cantidad de medios digitales, hablando de películas, canciones, videojuegos e incluso libros. Entonces mi pregunta sería esa, usted en esta discusión, en este debate, ¿de qué lado está?
Hopefully you can translate that, Carlos. I got a bit of it, but not enough to answer.
En el chat. Just check the chat, please. Wait a second.
Thank you. Digital goods, the right to use a license at the time of purchase. Please clarify the difference, how it affects the consumer. Oh, yeah, that's a good question. Oh man, this one really bugs me. You know, I have a lot of vinyl records, which is like an old person thing for music, right? And I'm buying a lot more vinyl records because when I buy things on services, sometimes they disappear. Sometimes the artist gets mad at the service and like I don't have the thing I bought anymore, even though I bought it. And so with music, I buy vinyl. I don't know what to do with videos, but you're right. Like it would be nice if there were some notion of persistence, some notion of once you buy a thing, you have a license to it in the form that you originally purchased it. But like, gosh, that feels very hard to achieve given the second you open up digital copyright, you get, you know, all the rights holders showing up. I can tell you right now, in the USA, we're really worried about the next time we try to reform copyright law, because it took 10 years in the 70s last time we did it, and it was a mess, and you end up with a whole bunch of things. So, you know, I think this is a really serious problem with things that aren't necessarily even digital goods, right? Well, I mean, so you mentioned books, movies, but what about software? Like this, there's a piece of code that runs in my dumb little light remote so that I don't have to, it doesn't work. So I don't have to go over here and turn my light off and on so that you guys get a nice side view of my ugly face, right? But this is no longer in the company that makes the thing is no longer in business, and the software like talks to the internet, which is dumb for a little thing like this that really doesn't do a whole lot. But we saw this with Nest thermostats recently, that Google is no longer supporting the first two versions of a Nest thermostat. So there are a whole bunch of people who now have to find new thermostats because it's going to stop working. It's just, it talks to the internet and it won't work without that thing on the other side of the internet. And so there's the question about licensing digital goods. And I don't know of a good answer for that, like a license that has sort of a guarantee to the consumer for persistence of the thing. For the Internet of Things and for software, it's even worse in that you have to kind of hope that that company stays alive, or that the thing can work if it loses its internet capability.
Es que le quería agregar algo al profe, ya me iba a traducírselo para dejarlo como más detallado, pero para el récord, digamos. Yo quiero dar un ejemplo de videojuegos que alguien te comentaba. ¿Hay licencia? ¿Es una licencia de uso o es un bien digital? Por ejemplo, Halo 2, juego que salió alrededor de 2004. Ya tiene más de 20 años de que salió y los servidores fueron cerrados. ¿Qué pasó? Desactivaron el multijugador, pero la campaña, el modo historia, se puede seguir jugando todavía. Es decir, quitaron la parte del servicio y lo que le quedaba al usuario que compró ese software, porque al final de cuentas en un programa, le quedaba el bien digital, que era la campaña o el modo de un jugador, que podía seguirlo reproduciendo incluso hoy en día que los servidores se cerraron. Es decir, quitaron la parte del servicio y dejaron el bien digital. A partir de ahí podemos dejar claro, o digo yo que es una parte importante para empezar a definir qué es un bien digital y un servicio, sobre todo medios digitales como los videojuegos. En este caso, encontramos que en este videojuego tenía una parte que componía el servicio y otra parte que era un bien. En este caso, el servicio sería la parte que depende del servidor para funcionar, y tenemos la parte del juego que es un bien y lo puedes disponer de él estando en cualquier otra computadora. Por ejemplo, tenían una computadora en el 2004, hoy tiene otra, y el mismo producto, el mismo software lo siguen reproduciendo 21 años después. Entonces, ese era como mi punto que quería agregar, que serviría como para empezar a definir qué es un bien y cuál es simplemente una licencia de uso que forma parte de un servicio.
Yeah, I mean, oh my gosh, these are really hard problems. These are almost philosophical level problems. You know, how do you think about what is a good versus what is a service? I hate pointing to this, but the Digital Millennium Copyright Act in the United States, the DMCA, has a provision that allows every 3 years, for some reason they chose 3 years, you can petition our Copyright Office to allow copyright infringement for certain kinds of things, digital goods. And so, for example, there is an exception from the prohibition on circumventing and access control. Sorry, that's the technical legal language. There is an exception that allows people who take books and make them accessible to blind people. And so you're allowed to crack open the digital good and free, so to speak, the contents inside, as long as you're providing it to people that have sight impairment or who are blind. That's not the best system, because you have to go every 3 years and ask for this. And there's some really cool stuff. The video game archivists, there are librarians for video games. I never knew this until recently, but there are whole librarians who all they do is maintain video games. these folks have used this process to get an exception to the DMCA to allow them to do things like, for example, set up a stub server for Halo 2, have a fake version of the Halo 2 service from 20 years ago that they've reverse engineered that can actually respond to some extent. So it's not exactly what you want because, you have to go 20 years in the past to get the actual service back, but to get some of the enjoyment of the good, we should be able to legally crack them open or interact with them in ways that, to use a US copyright term, that don't affect the market for the work. Unfortunately, these companies will often come out of nowhere and say, hey, now there's money to be made. You're affecting the market for the work, lawsuit. So you need a legal framework that actually says, no, we've decided that these kinds of uses in these kinds of cases are permitted. And for example, we got an exception to hack voting machines. The idea being that the companies behind voting machines really wanted to prohibit us from being able to look at them, and they were going to sue us. But we asked the Copyright Office, hey, you really want your democracy to be safe? How about you let us make sure we can figure out everything we need to know about these things and crack them open and figure out how they're doing bad things? That's a public good. And so ideally, there would be mechanisms to demonstrate that the good that this kind of thing that may be prohibited by the law outweighs the bad that could be accomplished by doing it. But obviously, that's not going to help anytime soon.
Thank you very much, Dr. Hall. To close, we want to thank everyone to join us today, and special thanks to Dr. Hall for sharing time and knowledge with us. Esperamos que esta sesión haya sido de su interés y de su agrado, y creo que todos nos merecemos un aplauso.
And please feel free to send me email at any point in time. If you have questions like the one, if I didn't answer them very well, I could try again.
Okay, excellent. Thank you very much. Sí,
Para tomar una foto.
could you please stay for a while? We are going to make a photo.
Okay. I'll try and look better.